Everybody, this is our a webinar on monetizing your intellectual property. This is the fourth in a series we've done on IP as part of the project we've been doing with the National Association of Community College Entrepreneurship and Michelson IP. And this is part of the IP Educator in Residence program from Michelson. So next slide, please. So I just wanted to, rules of the road here. One, this is being recorded. So just a note, this webinar is being recorded. Will also be posted to YouTube later. All attendees will be muted during the webinar, but you can use the question and answer or chat to submit questions. We'll be monitoring that throughout. You'll receive a copy of the presentation and resources by email following the webinar. And the webinar is scheduled for 1 hour. On to the next slide, please. Just going to offer some introductions here. So my name is John Diffley. I'm a professor of history here at STIC. I teach history, obviously. I oversee the honors program, the general studies program here, and I'm also a attorney. I'm part of the IP and Educator in Residence program with Professor Diane Sabato. Professor Sabato is a business professor with 20 years of entrepreneurship education, as well as being a small business owner. Today, we're honored and lucky enough to have two experts join us. One is Rick Kosakowski, who's appeared on our other webinars. He's the founder and principal of Swiftwater Law. He has worked for over 30 years in the legal profession, as well as 10 years as a technician and engineer. Rick brings unique insights in business, legal and technical skills to his work. He has worked with both startups and corporations and law firms that specialized in IP. Rick is actually an STCC graduate. He earned his substantive degrees going to school at night while working full-time. His professional career began as an electronics technician with Pratt & Whitney Aircraft Division of UTC. He was later named Chief IP Counsel for Pratt & Whitney in 2002, where he led the IP legal functions for the entire company. Rick has been registered practice before the United States Patent and Trademark Office since 1989. What this means is he's had to pass rigorous exams specifically for this purpose, in addition to the state bar exams. Candidates must have a science, technology, or engineering degree to sit for the USPTO exam, and he's been admitted to practice as an attorney since 1990. In Rick's legal and technical career, he has worked with all types of businesses. His current focus is on working with entrepreneurs and startup founders. He volunteers as a mentor for entrepreneurs and startups with the Valley Venture Mentors in Springfield and E for All Holyoke Startup Accelerator Business Program. Rick is also joined on the panel by Keith Walker, founder and managing director of Saratoga IP Advisors. Keith has experience in the IP lifecycle from conceptualization to monetization. Keith brings international business development experience in intellectual property creation, analytics, management, strategy, and monetization. His direct corporate IP experience includes working at Kodak, GE, IBM, and IGT. While consulting at Charles River Associates, he worked with clients worldwide, including Schlumberger, Ericsson, and Nokia. He is an experienced negotiator in licensing matters and resolving disputes. His deal experience includes formulating and negotiating patent, trademark, and software license agreements, royalty audit settlements, developing financial models supporting valuation, and developing deal structures to close deals. Keith also has many years of project development experience, enabling him to understand markets for leading-edge technologies and communicate effectively with scientists, inventors, engineers, and business executives. IAM Magazine has recognized Keith several times as one of the world's top IP strategists, most recently in 2019. Both Rick and Keith have volunteered their time to share their expertise with us today, and which we are deeply grateful. We are very lucky to have them share their expertise. Next slide, please. So here's the agenda, just a quick overview of what we're going to go through here. I'm actually going to turn it over to Rick now, and Rick and Keith are going to share their knowledge with us. And so next slide, please. I'll turn it over to Rick. Thank you.
All right, John, thank you for that introduction. Good afternoon, everyone. Before I get started, as an attorney, I want to give the standard disclaimer that basically any material and information that I present today in this webinar is intended to be just for general informational purposes now, and it should not be considered as specific legal advice or counsel. To that end, there's no attorney-client or confidential relationship formed between myself and any of the attendees. And if you do have a specific legal question or situation, I suggest you seek competent advice from counsel, IP counsel. So next slide. All right, so before we get into specifics on monetization of IP, let's talk about intellectual property itself. What is it? I mean, we hear the term all the time, but it's basically an umbrella term that covers the 4 specific areas of intellectual property. And those are patents, trademarks, copyrights, and trade secrets. All 4 of these are related to some extent, but they have some very significant differences between them. So let's start out by talking about patents. Patents, they protect inventions or discoveries. In other words, you've invented an improvement to a product, either an article of manufacture or a machine, or perhaps you've invented an improvement to a process, a method for doing something, for building something, or something that's embodied in software, let's say. So you believe you invented an improvement that's new and novel. So you want to attempt to get a patent to protect your invention. So what you have to do is you apply to the United States Patent and Trademark Office, which is a branch of the federal government, and you make an application. You have to disclose your invention in your application, and the process is lengthy and it's expensive. It takes about a year or 2 or maybe more before a patent issues. And during that pendency of the application, you have really no legal rights of exclusion. But if you get a patent issue, then you have the right to exclude people from basically commercializing your invention. You can keep them from making, using, selling, or importing into the US your patented invention. So again, patents are governed primarily by federal law, not state law. And they protect discoveries and improvements to things. Trademarks, on the other hand, they're part of your brand. They comprise words or logos or designs, or maybe a combination of both, that you use to identify products or services that you provide. So with trademarks, they can be governed by both federal law and state law. And federal law kicks in if you sell your products or you render your services in interstate commerce. So the linchpin of trademark law is that once you start using your mark on goods or services, and you sell those goods in interstate commerce or you render the services, then you have common law federal trademark rights in your trademarks, which you can enforce against someone who comes after you with a similar mark used on similar goods. The test for that is, would there be a likelihood of confusion between your mark as used on your goods or services and then the person or entity that comes after you with a similar mark as used on their goods or services that are somewhat similar? It's common to apply for a federal trademark registration. It takes about a year if everything goes well from start to finish. If you get a federal trademark registration, it gives you a number of legal presumptions. For example, you can use your trademark throughout the entire United States. If you only do business inside Massachusetts, let's say, because of licensing restrictions or whatever, it's possible to get a Massachusetts state trademark registration to issue. And that's much quicker. It only takes about a week or two to get a registration to issue for that. So then let's turn to copyrights. Copyrights protect expressions of ideas, original expressions of ideas. So we think about books, writings or music. We think about artwork or photography, websites, the content of websites. That's protected by copyrights. And they're protected primarily by federal law, not state law. And the common law legal protection begins when you reduce your expression, your idea, into a tangible medium of expression. So let's say you publish a website, a web page or whatever. The minute you publish that web page or website with a bunch of web pages, you have copyright protection. And we've all seen the copyright notice, the capital C inside of a circle, then the year of first publication, let's say 2022, and then the owner of the copyrights. And the owner is usually the author. It could be a work for hire, so it could be a company that hires you to perform work for them. The company or entity could be the owner, but most of the time, the author is the owner. You could apply for a federal copyright registration. And you actually need a federal copyright registration if you were to sue a potential infringer in federal court for infringing of your copyrights. It takes about 2-3 months to get a copyright registration issued. The cost is fairly inexpensive. It's less than $100 per application. The duration of copyrights, it depends on the type of work and when it was created. The different laws kicked in, federal laws kicked in at different points in time. But basically, the rule of thumb is a copyright, the legal rights, they last for the life of the author plus 70 years beyond that. So let me back up a second to trademarks. The trademarks, like I said earlier, once you start using a mark on goods or services, your rights begin. And those legal rights could last theoretically forever, as long as you keep using your trademark on the certain goods or services. A good example of that is Coca-Cola. They started selling Coca-Cola in the late 1800s. Well, the Coca-Cola company still has rights in their trademarks today because they've been continuously using their trademarks on their goods since the 1890s or so. So the first three areas, patents, trademarks, copyrights, we can think of those as formal intellectual property rights. So even though trademarks and copyrights come with common law rights, you have to make an application to the respective patent and trademark office or the US Copyright Office to get registrations to issue. So in that sense, they're formal intellectual property rights. The last area of IP law is trade secrets, and that I like to think of those as informal rights. And trade secrets are governed by both state law and federal law. And trade secrets embody any kind of business information that gives you, the entrepreneur or your company, a competitive advantage over someone else who doesn't know of that information. So it could be a list of your suppliers, who you get your different components from to use to build your overall product. It could be a list of your customers and their buying preferences, perhaps geographically or at different times of the year. It could be some kind of a recipe or formula that you use to make your products with, let's say. And it also could be a process that's embodied in software. Let's say you have some kind of a computing product and you have some proprietary software in there. You can use trade secret protection to cover that proprietary information in your software. Let's go to the next slide, please. Okay, so intellectual property, we like to think of it as a business asset. Intellectual property, including the four areas that I talked about, they're all intangible assets of an entrepreneur, a startup entity, or established company, as opposed to tangible assets. You know, when we think of tangible assets, we're talking about real estate and furniture and computers and things like that. Intellectual property is more of it's an intangible asset, but it has become very valuable over the last 20, 30 years or so. I just read an article that said that IP assets now average about 85% of the total assets of a modern day company, which is like reversed from where it was maybe 20, 30 years ago. So as an entrepreneur, you have patents, you have patent applications, you have trademarks, you know, either common law rights, or maybe you have a federal registration, you have copyrights. These are valuable assets for you. So as such, you can utilize them beyond, let's say, the normal type of activity where you may assert your rights against someone to keep them from infringing your rights and perhaps harming your business. But you can leverage your assets or your IP assets as a business asset. One way you can do that is you can use it as collateral or security to secure loans from a financial institution. I mean, that's not a new concept, but it certainly is very popular today. Thomas Edison in the 1880s, he had a patent on his light bulb. He used it as collateral to get a loan to help him start GE. So IP, you can pledge it as security to get money to help build your business. You can sell your IP outright, or you can license it. And what I mean by selling it is, you know, as an asset, you hold title to it, you know, whether it's a patent, it can be a pending patent application, it can be common law trademark rights or registered trademarks, trade secrets. You have title to all that. You can sell it to an entity. Perhaps you're not making use of your IP anymore, or a good example of that is if you have utility patents. Let's say you have a number of issued utility patents, and for a utility patent, the lifespan of it is measured as 20 years from the filing date, although the protection doesn't start until the patent issues. But once the patent issues, 3 times during the lifespan of the patent, you have to pay maintenance fees in order to keep the patent in force. So what a lot of entities do is they look at their patent portfolios quite regularly. They look to see if their products or their technologies are still being utilized by that entity, and thus they're still being covered by their patents. If not, if they're not using these patents anymore to their advantage, what a lot of these entities then do is they look to sell these patents. They're still in force. In other words, they've still been paying the maintenance fees, so they have maybe 5-10 years left on the lifespan. But instead of just letting the patents lapse and go abandoned, they sell them and they bring in money to help fund their businesses. When we talk about licensing, we're talking about the entity still maintains ownership of the IP, be it a patent, trademarks or copyrights or whatever. But by giving someone a license, you're basically allowing them to use your patented technology or your copyrights or whatever. You're basically promising them not to sue them for using your technology. So you can license patents to different entities to bring in to raise money. The thing with trademarks, the difference there is a trademark cannot be sold or licensed to someone without also selling the underlying business. And if you think about it, it makes sense, because in order for you to obtain and maintain trademark rights, you have to be using the trademark as part of your business. So you can't just hold on to your business and then sell your trademarks to someone else, because now you've disconnected the trademark from the underlying business. So, IP, the various types of IP rights, they provide you with a competitive advantage. So when you're looking to perhaps sell your business, buyers are going to invariably ask, do you have any issued patents? Where are they? They're going to want to look at the patents. They want to see what the claims of those patents cover. What technologies, what products, what processes. So when you get a patent to issue, that means the United States government or the government of a foreign country has gone through the examination process and believes that the claimed invention is novel and thus it's worthy of a patent. So then the rights you get for a patent are to exclude people from commercializing your invention. So those are, for an issued patent, those rights are very powerful, and they attract a higher price typically than if you had no patent or even a pending patent application. Then finally, IP begets new IP. The culture, if you've created a culture within your entity or company where you reward creativity by, let's say, giving monetary awards to inventors or whatever, it's kind of like a snowball rolling downhill. It's going to pick up momentum, and you're gonna encourage your employees, the people who work with you, to create new intellectual property. So it's important to foster that creativity within your entity. So, all right, I'm going to turn it over to Keith. So next slide, please.
Thanks, Rick. I appreciate that. By the way, when you were talking about trademarks, you mentioned what can comprise a trademark, whether it's a logo, design, words, and such. I believe also audio can be trademarked, because Harley-Davidson had trademarked the sound of their exhaust. And my question is, can taste or smell be trademarked?
Yeah, smells, colors.
All right.
All kinds of different non-traditional things, as long as it's capable of identifying a source of goods or services, then it can function as a trademark.
Okay, yeah, thanks. So, and that kind of comes to the point too of what do you file on? What do you consider an invention? What do you consider, part of your business from an IP standpoint? And that's what I'll talk about that here a little bit. One other thing I'd like to comment on with respect to the prior slide that Rick showed is IP ownership. In order to make sure that, it's your asset, you have to be very clear about title on the asset. And this has come up in numerous cases where there have been disputes over who really owns the patent. It's come up in corporate cases. It's come up in joint ownership type cases where you've got two companies that are potentially collaborating, or a university and a company that have a JDLA with each other, and that sort of tech transfer thing. Professors arguing over their ownership, ex-wives, sorry out there, I should say ex-spouses, in divorce cases where there's been fundamental IP that's worth money. So part of, as an entrepreneur and a business owner, you will want to be very clear with your employees, even yourself, if you're that inventor, as to who actually is registered as owning as having title on that piece of IP. It's important. And as Rick mentioned, you can leverage these assets to get loans, and the banks will want to know that they have clear title, much like real estate. So I'm going to talk about IP management, IP strategy, where you file, when you file, that kind of thing. The patent law in the United States used to be, this is prior to 2000, I believe, when it was first to invent. So, you're an inventor and you have a great idea, and you had to keep a notebook, and you had to have a witness or, someone authorize It was kind of your invention, et cetera. And you could hold on to that idea for quite a period of time until you were ready to file. Now the law has changed and we're more in sync with the rest of the world where it's first to file throughout the world. And this, in essence, you get, for a patent, you get 20 years from date of priority filing in that patent family, which we can talk about more. But in essence, you have 20 years from that priority date for the life of the patent. Now, there are some extensions that can come into play based on delays at the patent office and other issues. But point here is, as you're managing your innovative process and the inventors that are working for you, with you, third parties that you may have retained as consultants, and et cetera, you want to have a process where you can identify an invention. So, at Kodak, IBM, GE, big companies, there's typically an invention disclosure system. And then there's a invention review board often, where you have a number of the technical representatives, potentially a business representative or a marketing representative, that review these invention disclosures to weed them out, the wheat from the chaff, in terms of, well, we think this will be valuable, or we think we can let this go by the wayside, or, oh, maybe we want to keep this as a trade secret. Trade secrets never expire. Patents do expire. The risk, however, with keeping something a trade secret is that, well, somebody else may come up with that invention and patent it, and then you would lose your trade secret effectively. However, you should have a process in place to identify what you consider to be your inventions, your ideas, and your inventions. A database, anything ranging from, a collection of Word documents to an Excel file to document these things, keep them organized. There are also third-party software products available in the market. I used to use at Kodak, we used to use a system called Delphion, which became a Thomson Reuters product and also had some IP management capabilities within it and so forth. You need a little bit of, let's call it, software administrative support to track those ideas, and then decide which ones to file on. Finding a good lawyer, a good IP lawyer, is key. Someone who can appreciate the domain that you're working in, the technology, the prior art is going to be very helpful, because they will help you navigate and decide what is actually patentable or not based on earlier prior art, that kind of thing. And you can file on your own. Many inventors have done that. It's not an impossible process at all, but it's time consuming, and it may be something you may not have time for. So depending on your workload and so forth, choosing to file on your own, how much knowledge you've got relative to patent law and prosecuting a patent, having discussions with the patent examiners, et cetera, how comfortable you are with that, it's your call. But I guess my recommendation is, based on my experience, having a good IP lawyer to take that workload on is worth the money. And then, of course, you filed all these patents. Now, depending on your product strategy and launches, and I referred to a patent family earlier, you have to consider what jurisdictions you want to obtain IP rights in. US, Canada, Japan, Germany, England, Korea. Just depends on where you think, China. It depends on where you think your products are going to end up. If you're a consumer products company like a Procter & Gamble, you're probably going to file worldwide, or you're a pharma company, right? Merck, Novartis, et cetera. You're going to file worldwide. You want IP protection around the world as best as you can get it. If you're just a kind of, let's say, a semiconductor company, you may not need all that protection. You probably want to file in places where your key competitors are, your manufacturing facilities are, et cetera, where you may get injunctive relief. But another nuance of the patent law is that a product which is manufactured, let's say you have a semiconductor process that's used to build a certain chip, and you've got a US patent on that, but you do not have a German patent. So that process could actually legally be used in Germany to manufacture that chip. However, that chip could not be imported back into the United States. It would be an infringing product. Okay. Now, you may want to get the German patent in that case anyway, because you can get injunctive relief in Germany. And that's, kind of one of the tools in your arsenal if you're in a patent infringement case to put some pressure on a competitor or an infringing entity, right? So those are the kinds of things to think about when you're genning up your portfolio, starting it up, and think about where do I need to file. Now, with that decision also comes cost, because as Rick mentioned, in the US, you've got 3 periods to pay what are called maintenance fees here in the US to maintain your patent. If you don't pay those fees, your patent will expire, will lapse. In Japan, as an example, you have to pay on a per claim basis to maintain claims, and it can get very expensive. So, you really have to decide, okay, what's my budget for managing this portfolio? How much can I invest, et cetera? Again, that ties back to your overall business strategy as well. Okay, I think that covers it. So next slide. Okay, monetizing IP. This is something that I've been involved with for, I hate to admit it, over 30 years in various ways, shape, or form. Licensing, as Rick mentioned before, patent sales. I've sold patents out of a bankruptcy for a bankruptcy trustee. You can also kind of trade patents for other assets sometimes. When people are buying the business, they may want certain patent picks out of a business and then sell some other stuff off. So, again, it's an asset much like some of the furniture in the office and computers and so forth. But how do I monetize this? Well, one thing you have to consider is a reasonable value to place on it. A lot of this will come down to, comes down to pricing, if you will. Again, it also goes back to your business strategy. Licensing is attractive if you are somewhat resource constrained, if you have limited manufacturing capacity for your product. You may want to have a licensee that, can actually expand the market for you, and you benefit because you're collecting a royalty from that third party product or that OEM that's manufacturing the product. If you want just to be a monopolist and you want to maintain all the rights, well, you can do that. And then if there are infringers out there that are infringing your patent, making, copycat product, or, even your trademark or copyrights, they're making copycat product and selling it into your market, and you've got IP protection, well, you can go after them for infringement, right? By the way, I do want to also comment on the types of patents. There's a utility patent, as Rick mentioned. There's a design patent, and there are plant patents. And in fact, the battle that Apple and Samsung had in the ITC, which is the International Trade Commission, the patent infringement case they had was over design patents, and it was worth billions of dollars at the end of the day. So consider that as well as part of your IP management or portfolio creation is, types of patents you can get, right? Utility, design, and plant patents for those that are now interested in the cannabis industry, right? As a matter of fact, most of the plant patents I've ever seen have to do with various ornamental type plants like flowers, roses and carnations and things of that nature. At any rate, I'm a little off track, but how do you determine, in order to monetize your IP, the hammer approach is I'm looking for infringers, right? How do I determine who's infringing my IP? And in the patent space, we do that through what we call collecting evidence of use, finding evidence of use. So, you may be suspect that Apple is infringing your patent for some chip design or something like that. Well, you've got to go take a look at their product, try to pull technical specs for that product, and see if you can match up your claims language to what those technical specs are, right? And that's, it takes some engineering, it takes some technical insight to be able to do that. Assistance from a patent attorney to help interpret your claims language, any restrictions that may be on that claims language relative to the patent specification and so forth, any limitations of the claims language. But it's a reasonably straightforward process where you're trying to pull publicly available technical documentation and you're trying to match that up with what your patent claims are. And that's what we would call finding evidence of use, or at least searching for evidence of use. Let's say I found some of that and I'm pretty sure there's some infringement. Well, then I'm going to talk to some attorneys about filing an infringement litigation. And you file infringement litigation typically in the federal district court system. There's a big battle now over venue selection because the Eastern District of Texas, which you may have heard of, has an enormous number of patent filings. There's a particular judge there, Gilstrap, who is very much a kind of a IP owner advocate, plaintiff kind of advocate. So if you can file in the Eastern District of Texas, it's usually been beneficial for the plaintiff. Delaware is somewhat of a popular jurisdiction. And for a lot of high-tech companies, you want to avoid the Northern District of California because it's viewed, the judges there are sympathetic to, the high-tech companies that are in Silicon Valley, the Googles and Cisco's and Intels and so forth. It's changing slightly, but I bring this up because, again, it gets back to monetization and the likelihood that you would succeed in a patent infringement case. A typical infringement case will probably depends on the technology. When I was director of licensing at IGT, we were talking with an outside law firm to assert some basically software related patents in the gaming space. And we were talking on the order of 10 to 12, $14 million from beginning the case through trial to finish the case. Now you can settle along the way, save some cost, et cetera. But it's an expensive proposition. And point being, you're probably going to want 50 million or 25 million or more in potential damages to make it worthwhile, and expect a fairly long time frame, 2 to 3 years to get any kind of answer. As Rick was talking about before, you can basically raise money through selling either IP directly, selling patents directly, or through debt, IP backed debt, right? Liens on your IP. So you can raise money that way. In the patent sales that I've conducted, you try to put together a reasonable valuation model. And actually, when I was at GE, I had the role also of reviewing patents that were submitted to GE for sale. And they often came in with marketing pieces that talked about it's $1 trillion total available market. You're looking at this highly valuable collection of patents, et cetera. And I've never seen a patent, that single patent, very few, that were ever worth about $1 billion. So, you have to really have the proper expectations about what your patents are worth. And that's where, somebody like myself has come in with valuation experience to look at, okay, how do these patents relate to the market? What kind of discount rates do we use to discount this back on an NPV basis and so forth? There's a kind of a business case process that you go through to come up with a rational valuation of the patents. You can also sell your company. If your company is largely IP based, as Rick mentioned, there's a lot of basically shareholder equity on the balance sheets these days. I think a good example I can think of where IBM purchased Red Hat for 60% premium over Red Hat's closing price the day that they announced the deal. A lot of that premium would have been essentially tied up in IP or attributed to IP. it's, you know, without going through a very rigorous valuation process, it can be a little difficult to identify. But that in essence, that premium that IBM paid for Red Hat would relate to the underlying value of the IP that they own. You want to go to the next slide? IP businesses, can you set up a licensing business as a profitable business? Yes, you can. Often these have come out of an initial product development type business. So Qualcomm is probably one of the best examples that I could think of. You know, the inventors there, the founders there, Irwin Jacobs and so forth, basically invented CDMA. Although I think some of the original CDMA stuff goes back to, she's a famous actress, and I'll remember her name in a minute. But in essence, Qualcomm had to build a phone, a handset, and take it to market to enable their invention to become used and broadly used. CDMA was the underlying invention, code division multiple access. And, you know, eventually Qualcomm got out of the handset business. They don't make handsets anymore. They do make chips, and they make chipsets, but they largely turned into a licensing business because they obtained the fundamental patents that read on CDMA in the mobile wireless space. Of course, they got into major battles with Nokia, Ericsson, et cetera. But at that point, they had the money that they could fight those battles. And there is something else in the IP space known as a SEP, which is a standards essential patent. And there's a lot of fighting over those types of patents in this wireless connectivity space. These are patents that read on a particular standard, such as 4G, 5G, LTE, et cetera. A company that has made a lot of money because their patents read on those standards is InterDigital. They've also invested billions of dollars of R&D to develop those patents, and they have a lot of really smart, you know, engineers. Some of them had legacy from Lucent, et cetera. So they really know what they're doing relative to building solutions or inventing solutions that solve problems for those standards. When I was at GE, we had a patent that was a turbo coating patent, which is a noise reduction technique that goes into you know, wireless transmission, pretty fundamental. And so, you know, you may have patents like that could read on some of these standards, and you could potentially then set up a business with those sorts of patents. Another prime example, that in a recent example of a company that's making money from its portfolio, or made money from its portfolio, I guess you cashed in, is BlackBerry. You may have seen this in the news, the business news. They recently sold a portion of its portfolio to a private equity firm for $600 million. And that new entity will become essentially a licensing entity. So yes, you can develop a business that's an IP licensing business. You can do that around brands as well, you know, just a pure branded type play. I mean, McDonald's in a sense is also kind of a brand play, right? As a franchisee, I'm basically licensing the McDonald's brand, and that's you know, worth X these days. I guess $1 million or something to probably set up a McDonald's business. There are also
sorry to jump in, Keith. Just one thing, two things here. One of the questions I saw in there is for a small business with limited resources, which of these strategies are within reach? And the other thing is just a reminder on the time. We want to leave a little bit time for the
Sure.
But yeah, what ones would be best for a small business? With limited resources. Yeah, you know, I know it's a wide question.
So with in that regard, I say make your product. You know, build a solution and, you know, get a working prototype, and you might be able to sell that off to a larger entity. Had one inventor, that's still a tough putt. I'm a golfer, so I use putting as an analogy, but one inventor when I was consulting had developed a technique to do real-time imaging in an MR bore. He came up with both a patented technique to do that using piezoelectric motors with this apparatus that he developed to move somebody's knee or joint within the MR bore, and also a trade secreted grounding technique so that you didn't have any kind of electromagnetic interference in the bore. We went around to Philips, GE, other Siemens, and tried to pitch this. And it's a great idea, but they didn't bite. They didn't see the business case for it. So it's, try to make your product, take it to market, and I'd say that's your best bet.
If I could add to that, try to add value to your product through intellectual property by doing a patentability search to see if your invention could be patentable. Also, maybe do an infringement search to make sure your product doesn't infringe anyone else's enforced patents. Then take it up a level. You file a patent application, either a provisional patent application here in the US or a non-provisional. And then way above that would be if you can get a patent to issue from the US Patent and Trademark Office, then you've added quite a bit of value to what started out as your product or your idea.
Yeah, and some of the VCs that are out there now are more IP savvy than they used to be. So, Kleiner Perkins Elman, they kind of appreciate the value of IP. You may get an angel investor that was an inventor themselves, and they might see the value in what you're doing and decide, yeah, you're worth $1 million. I think I could fund you, that kind of thing. Universities with professors, they spin out their inventions in a kind of incubator situation. So some of it could be a little context driven, I guess, and you're situationally driven. So do you want to go to the next slide? I hope that answers the question, Webb. So,
yes, thank you.
I guess this somewhat ties to what we've been talking about here in terms of monetizing, in terms of creating a business around IP. How do you find and acquire IP to license? Well, as Rick just mentioned, you can go out into the patent databases out there with a keyword search. Let's say you're looking for some kind of low power LED type device at certain wavelengths, whether it's 450, 550, 650 nanometers, something like that for, the blue, green, or red, or what have you. And you want to have a light bulb. You want to create a new light bulb using those LEDs, right? And you got a really great idea around, having a multicolor light bulb or something, and so, you're not an LED manufacturer, but you could do a patent search looking for the kind of LED that you want to put in your light bulb. And, you may find somebody you may find an inventor that is sole inventor, and you could work a nice deal with somebody like that rather than going to Cree, and Cree being one of the large, I don't know if they call themselves Cree anymore, but the larger LED kind of manufacturing places. So, that's what I did at Kodak a lot. We did patent searching on our competitors. We did patent searching for new ideas in the inkjet space. We did a lot of patent analysis on that. And in some cases, we would license in patents that we thought we needed to enable our product to work in a certain way. There are brokers out there, self included, that could help in terms of knowing what portfolios are for sale, or help you sell a portfolio. But there's sort of I guess it's almost a private market, if you will. It's a market that exists being networked through people such as myself that have been involved in the IP, I call it industry licensing business, for decades. And we become aware of patents that are available. So again, BlackBerry has just made this new tranche of patents kind of available, if you will, right? This fee structure that goes with that, oftentimes there's a 10% success fee that may be involved in the success of selling patents. 15% depends on the amount of effort and size of the portfolio and things like that. Okay, I'm being prompted to ask about working with engineering schools and I guess helping with licensing or those sorts of issues. Sure. I mean, it's always fun. I've always been, one of the things I love about the IP space is the nexus between R&D, technology, business, and law. And inventors are passionate about their ideas. Oftentimes they don't really have a good handle on where to take them. And someone such as myself that's had exposure to a number of markets, number of what I want to say, additional ways to use the IP can be helpful in finding ways to monetize that IP. So sure, it's always, I think it's good to have third parties come in and give you some external objective perspective on what you own and what you think it's and what they think it's worth and how you might go about approaching the market for it. So does that answer the question?
If I may just add for universities and colleges that they, much like businesses like Apple and Raytheon and MassMutual, companies like that have become more savvy and in tune with their intellectual property. So they're getting more of it, they're monetizing it. So too have colleges and universities. They most of them now have technology transfer offices. They know the value of the IP that's created by their professors and their students. And a quick story, 30 years ago in 1992, I was in-house with United Technologies. I was responsible for patents and IP coming out of a semiconductor facility in Colorado Springs. And the University of Colorado at their Colorado Springs campus was able to obtain one of only 2 machines in the world to deposit a certain type of silicone for an integrated circuit. And I was able to negotiate with the university back then, and I achieved very favorable licensing terms for United Technologies. Today, I would never have been able to get those kind of favorable terms for an entity like that. Why? Because universities are a lot smarter about their IP. They're just not going to give it away like they used to 30 years ago.
So I think, do we have any other slides, another slide, or are we open to questions? Okay, questions, there we go. Other questions?
If you don't mind, I'm going to jump in real quick. This is Diane Sabato. I just want to make sure, because we're probably going to run out of time, that I thank everyone for coming to the presentation. You will be receiving a copy of the presentation. And if we don't get to it, there is a slide at the end that includes links to the previous 3 webinars that were held on intellectual property, including some of the basics, how to defend, what you do if people are infringing. It's some great content on our STIC YouTube channel. There are links to the Michelson Institute for Intellectual Property that are working with the National Association for Community College Entrepreneurship. They have a free online open source class that you can take on intellectual property, a whole bunch of videos and web resources, a number of tools. And that initiative is started by a gentleman who actually is a prolific inventor. So it's pretty interesting to see the initiatives that they're moving forward with. Again, we want to thank everyone. And I want to, before we leave, make sure we give double and triple thanks to Keith and Rick for sharing their expertise and joining us today. So I just want to make sure to get that in before we run out of time. And the recording will be available. Yep. Sorry, Rick, go ahead.
That's, I just want to, are there any questions? Because if not, I just want to make one point on a couple slides ago that Keith was talking about. I find that entrepreneurs, they love to search for patents, not only to see if what they think they may have invented has already been covered by prior art. So in other words, someone's already thought about it, but they also like to see who owns these patents. And Keith touched upon that a couple slides ago, figure out who owns the patents. Well, patents are, the owner of an invention is the people, the one or more inventors who invented it, they conceived of it. And then if they file a patent application, If they don't transfer their ownership rights to an entity or to someone else, another person, they still own it. So then when a patent issues, if they still haven't transferred their rights to anyone, then they're listed as the inventors. There's no assignee listed on the cover of the patent. So that means the inventors own it. So as an entrepreneur, if you want to go find who the owner is, you initially start with the inventors on the patent. But if they've assigned their rights sometime before the patent issues, there's going to be the name of a company there, like Mass Mutual or Raytheon Technologies. But that doesn't end the inquiry there, because patents are sold all the time after they issue. But the US Patent Office will not reissue the patent with an updated owner or assignee every time that happens. So if you look at if you find an issued patent that you're interested in as an entrepreneur, maybe taking ownership rights or license rights, the US Patent and Trademark Office website, which is uspto.gov, they have what's called an assignment database. And you find that database online, just do a Google search, you'll find it. And you plug in the patent number you're interested in, and it'll tell you who owns the patent. Maybe it is the original entity that was printed on the cover when the patent issued, but maybe it's been transferred once, twice, 3 or more times. Find out who that current owner is, then go talk to that owner to see if they're willing to sell the patent or license rights to you as an entrepreneur, so you can have access to that technology without worrying about getting sued for infringement.
One other thing I'd bring up is Google also has their patent search capability. They try to care for reassignment as well. And they also provide some of that family information I was talking about in terms of foreign filings, foreign publications that are part of that same priority application. There's one invention per application, basically. And so foreign filings are just added to that particular patent family.
Right. And patents are territorial. So as Keith alluded to earlier, there's no worldwide patent. You get a patent in the United States, but your invention has commercial promise to you in Europe or China or Japan. You have to go and apply for and try to get a patent in each of those various countries. So
I have a kind of maybe a last question, because I know a lot of people on the call are students at the various colleges and universities, and a number of our students are creating intellectual property. And it may be creative, it might be art or music or video production or a process. And they join this call or the Zoom because they wanted to figure out how they can now make money with that. Do you have a recommendation for a first step? I'm guessing it might be find a good attorney, but where to begin? Because some of this can be pretty daunting.
Well, I'll take a shot at that, not knowing exactly what the IP is, but example, I guess if you're producing stuff, video content, let's say it shows up on YouTube, I mean, you're basically, I guess, going to get paid for some volume of YouTube hits that you might get. I think TikTok is somehow the same way, although I'm not a big TikTok user. But, you know, that's sort of the model in the social media space, right? That you're getting paid as a content provider through the number of hits on your content. Now, there's this new notion of NFTs, which are non-fungible tokens. And I mean, I think of that as sort of the digital baseball card, right? You know, and if, you know, we'll see where that market goes. Supply and demand is an interesting thing in those spaces. When I was at Kodak, stock photography, for example, so professional photographers that were licensing their pictures for certain purposes, you know, might get $200 for an ad. So let's say they had a stock photo of, I don't know, the George Washington Bridge that New York City really liked or something like that. And New York City wanted to put it into a campaign, an ad campaign to come, a tourism campaign to visit the city. Well, that photographer might get $200 for the use of that photo for that ad campaign. You know, I don't, you know, some people have gotten lucky, I think, as YouTube content providers, or they something goes viral and all of a sudden they may be making lots of money based on some content they've put out. The Kardashians have been exceptional in how they've leveraged their brand for what they do, which I still don't quite fully appreciate myself, but that's okay. That's another story. I'm old fashioned, I guess. But yeah, you know, just make sure, I guess, just make sure that you've protected your creative work. Make sure that that's clear. Make sure that you own it. And the way, you know, the copyright is sort of de facto, right? Once you publish it, but it does pay to put a copyright notification into your work. At Kodak, when we were writing software, I'm a software engineer by training. We had in our header, you know, the comment header, we had copyright Eastman Kodak Company, such and such a year, right? Taking those basic steps is a first step in protecting your IP.
And just to add to that, let's say you've invented a solution to a problem. It's a product or a process. You're not ready to file for a patent application, but you want to talk about your invention to somebody. I would strongly suggest you use confidentiality agreements or non-disclosure agreements before you talk in detail to anybody, because if you just start at a networking event, let's say you start freely talking about it, or you publish information on your website, then in the United States, you start a 1-year time period running within which you have to file a patent application. But most foreign countries are not as forgiving. So if you go to a networking event in downtown Springfield, let's say, and you start talking about it to someone who's under no express or implied obligation of confidentiality to you, then you've now prohibited yourself from filing a patent application in Germany, England, France, a lot of these what are called absolute bar to novelty countries. It seems harsh. You're like, well, all I did was talk about it to somebody in Springfield. We had a couple of beers at White Lion, and now I can't file for a patent in Germany. Well, that's how the law works in that case. So you can avoid those harsh consequences by using agreements. Get these people to sign before you explain your invention in detail to them.
I'll bring up an example that's maybe a little controversial for this audience, but I think germane. My oldest daughter went to Case Western Reserve, and she was a chemical engineering student there. And one of her professors in chemical engineering class for the lab wanted the students to develop a solvent that would remove gum from the sidewalks. He got a grant from a manufacturer to help develop this solvent. And he had the students sign off on a contract, essentially, that any IP they developed would belong to him. And I reviewed that for her. And I said, you know, Courtney, her name's Courtney. I said, Courtney, do you understand what you're doing here? You're assigning your rights, any rights you have in the development of this solvent, to your professor, you know? So I guess the point being is just be sure you know what you're signing or what your obligations are as a lab technician at school. You know, your IP, if you invented something in your lab at your university, it's yours. That's your invention. Okay. And it's and actually even at a corporation, you know. You know, just be aware of what your contractual relationship is with either your employer, your educator, your partner in business, etc. Make sure you know what the rules of the road are, which is where we started this presentation.
Thank you. That is a good one. It is always good to read before you sign anything. That's always a general. Make sure you read that stuff. That is always helpful. I just wanted to thank you because we've gone over time and we're respectful of everybody's time here. But thank you, Rick and Keith, enormously for this today and sharing your expertise. We're going to be sending out an email, right, Diane, with all the information, contact information, links to this and previous ones, and contact for all of us. Again, thank you thank you to everybody for attending. Again, thank you, Rick and Keith, for joining us today and sharing with us and educating us all. Thank you, everybody, and thank you. Hope you enjoyed. Thanks.
All right, thank you, John and Diane, for having me. I appreciate it.
Of course, thank you. This has all been a pleasure working with you. Thank you.